Hi, Glenn Goldman from Goldman and Daskell Personal Injury Attorneys. And one of the questions that I've been asked the most in my 31 years of practice is why do I have to use my own insurance if somebody else is at fault and causes an accident and injures me? And the answer to that is that Florida is one of 12 states in the United States that require mandatory personal injury protection, PIP coverage. And that is the part of the Florida insurance law that is the no-fault part of the insurance law. And so personal injury protection pays 80% of your medical bills and 60% of your wage loss if you're injured in an accident, regardless of fault. It doesn't matter whether you're the person who caused the accident, whether you're the person who was hit by a car as a pedestrian on a bicycle, you were rear-ended. You always have to go through your own insurance regardless of fault. And just to give you a little bit of a history about the PIP coverage in Florida, between 1920 and 1940, scholars were trying to figure out a way to compensate accident victims. Between 1940 and 1970, accident cases rose so tremendously that the Florida legislature in 1971 created PIP, or personal injury protection. As indicated, regardless of fault, you must submit your own medical bills and your wage loss through your own auto insurance company. Since 1971, that law has been reformed many, many times, and so currently, PIP will pay 80% of your medical bills, 60% of your wage loss, up to $2,500, unless you have an emergency medical condition as indicated by a nurse practitioner or a medical doctor, and they'll pay up to $10,000 of your medical bills and your wage loss. The most important thing about personal injury protection coverage is you must seek medical treatment within 14 days from the date of the accident, or you will not be entitled to any personal injury protection coverage.